For those of you who don't know Anastasia, because we used to hide doing our presentations, but we are delighted to have a change and a very beautiful face in front of us. Anastasia is one of the directors of STBB. She works out of the offices in Sandton. Anastasia regularly used to give our training when we had, we used to do our training in 4 ways, always very entertaining, extremely knowledgeable. So Anastasia, thank you so much for joining us today. We really appreciate it. And I'm going to hand it over to you.
Thank you, Michelle, and good morning, everyone. I was chatting to Michelle a little earlier on, and I was saying to her, I'm so happy to be doing this training with you today. As Michelle said, I've done a lot of training for Leapfrog over the years at your conferences within my region. And when the training for this year was scheduled with STBB and Leapfrog, I said, I'd like a chance. I'd like to just engage with you all again on a national level. So I'm really excited to be doing this today. There's no PowerPoint. Michelle will tell you, I like to keep it simple. I just like chatting to you and to give you a few tips and to give you a bit of advice, anything that I can do from my side to make your lives easier. So please feel free to ask questions and we can deal with them after my little chat with you today. So I have been asked to talk to you about 2 of the clauses in your agreements, which are the subject to sale clauses and the right to continue marketing clauses. And I've been a conveyancer for many, many years. So this question has been posed to me hundreds of times. People ask me, is there a standard? Is there a standard that we follow when we draft our agreements? Should it look a certain way? And there isn't a standard. Unlike the property condition report or your disclosure forms that you use with your sellers and your buyers, where the PPRA is very clear on what it must look like, when it comes to these clauses, the Alienation of Land Act has some minimum requirements, but it does not dictate what these clauses must look like. So what that means is that they are created contractually. Your contract creates those clauses. And there are hundreds of different contracts in this market, but it is what it is. When I deal with that clause, I don't look at a standard or an example. I look at the clause in your agreement, your deal that I'm working on right now. So it's very, very important for you to understand that the only way that these deals can, these clauses can be dealt with properly is that there is consensus between the parties with regards to what those clauses say. An absolute understanding. The seller must understand it, the buyer must understand it, and the agent must understand it. I'm often asked as a conveyancer, I get calls, and they ask me to interpret those clauses because of things that are happening in that deal. It's too late. And it's difficult for me to interpret that clause because how do you want me to interpret it? Do you want me to interpret it in favor of the agent? Do you want me to interpret it in favor of the seller or in favor of the buyer who want 2 different things? It's very difficult at such a late stage to interpret it. I mean, I can interpret it, I'm a lawyer, but to interpret it so that everybody is happy. Somebody's going to be unhappy. And many times, and it could be the agent. So if we understand this is something that we take responsibility for as estate agent, as property practitioners, when we draft our agreements, and then when we conclude an agreement between the seller and the buyer, that the seller and buyer absolutely understand what those clauses mean and that we know what those clauses mean, then there shouldn't be a problem later on in the agreement. And if we talk about the right to continue marketing clause, that 72-hour clause or that 48-hour clause. It's an enigma. It shouldn't be complicated. It's a simple concept, but in my experience, it does become very complicated sometimes. And I have to tell you, for the purposes of this chat with you today, I haven't looked at all of your clauses. I know the clause for the Joburg Northeast branch because I work with Michelle Cohen and her agents, so I know their sale agreement. I don't know if all the franchises use the same clauses and the same agreements. I'm going to give you a general chat today. I'm going to give you my tips today. And then you can go back into your offices and in your branches and have a look at your clauses, chat to each other, chat to your conveyancers, and action anything if you feel it is necessary. But today, I'm not talking to you about your clauses. I'm talking about the clauses. Okay. So we know the first tip. We need to understand our clauses firstly. And then we need to make sure that our sellers and our buyers understand those clauses when they put pen to paper. Okay. And when we talk about that subject to sale clause the right to continue marketing clause, we need to be very clear in our minds about certain concepts. So the first thing is this other offer that the seller could get because they're continuing to market. What are we going to call that? What are we going to call that second deal? In some agreements, I see a higher offer, or I see a non-suspensive offer, or I see a higher cash offer. I see a lot of different options. When I draft that clause, I call it a competing offer. And I do know that the Leapfrog agency that I work with also calls it a competing offer. That is my suggestion. And if you call it a competing offer, in my opinion, you are doing the right thing because it protects your seller. It gives your seller that freedom and the leeway to really consider that second offer. When the first offer is concluded and the agent sits with the seller and says, you have the right to continue marketing, but only compete if it's a higher offer. At that time, the seller is thinking, yes, that's what I want. If I'm going to have a second option, I want it to be higher because that is better. But during the transaction, the market dictates what is better. And it's not necessarily higher. Maybe a higher offer can't be achieved, but a non-suspensive offer can be achieved, or a lower offer, but it's a cash offer. And the seller may then want to invoke the 72-hour clause, but the seller's not allowed to because the wording in the first deal says higher offer. So consider that, make it a competing offer so that the seller really has that opportunity at that time to decide this is a competing offer, even though it's a lower offer. And I want to invoke the 72-hour clause. And after all, that is exactly what you promised the seller when you recommended and gave the advice to the seller to accept the first offer. You said to the seller, accept the first offer. But if a second deal comes and you really want to accept that second deal, then you have the right to do so. So you are just implementing what you said to your seller and what you promised to your seller. So my suggestion always is to call it a competing offer. The second tip that I want to give you is with regards to the timelines. What is 72 hours? What is 48 hours? What is that? Well, it is what it is. But what happens if the seller wants to invoke the 72 hours and the buyer it's a Friday afternoon, and you know your buyer has gone away for the weekend. They've gone to the bush. They don't have access to their phones. They don't have access to their emails, and that notice period cannot be invoked. So go and have a look at your contracts and go and see exactly what it says about the times. I've seen contracts, and I've seen a leapfrog contract that says 72 hours being 3 business days. So that's just a tip to go and have a look at it, because the seller needs to invoke that time and notice period when the seller needs to do it. And if the seller can't do it because the contract doesn't give them the freedom or the explanation of how to do it, and the other party isn't available, it becomes a problem. And we think it's not really a problem. Let's just wait until Monday. But I can tell you, I've seen those problems. We all know that our sellers and our buyers are, with all due respect, crazy. We know that. We know we deal with complicated. We know we deal with stressed and anxious sellers and buyers. We don't want to make it more stressful and more anxiety ridden for them. So we need to be very, very clear on that timeline. The next tip that I want to give to you is with regards to when that notice period is invoked. The notice period is invoked when the seller wants to accept the competing offer. That's when it must be invoked. I'm going to go back to that because I'm going to give you 1 or 2 examples of things that went wrong. But I want you to remember this. That's the rule. The notice period gets invoked when the seller wants to accept a competing offer, not when the seller has accepted a competing offer. When the seller wants to accept a competing offer. So before the seller accepts that competing offer, the seller invokes the notice period. And depending on what happens in those 72 hours or 3 business days or 48 hours or 2 business days, depending on what happens then, the seller may in the future accept the second deal or may not accept the second deal. So that's about when it gets invoked. The third or the fourth question is, how does it get invoked? So some agreements say when the seller has a competing offer that they want to accept, the seller needs to give notice in writing to buyer number 1 and afford them a 72-hour period to meet or beat. Most agreements say the seller. And I have seen how this causes great anxiety. And so when I draft that agreement, or when I, on a private deal, or I help an estate agent to draft that agreement, I chat to the estate agent and I say to them, let's consider putting into that clause, when the seller wants to accept the competing offer, the seller shall instruct the agent or the conveyancer to invoke the notice period in writing to the buyer. And I know that means a little bit more work for you and I, but I think we need to accept that our sellers aren't experts. They are stressed, they are anxious, they are not sure. Then they start asking questions. Must I phone them? I don't have their number. I know it's on the agreement, but I threw away that agreement after the agent sent it to me. Must I email it to them? What does writing mean? Is a WhatsApp in writing? So don't put that on your seller. It's not fair to put that on your seller. You are the expert in the transaction. So my suggestion would be that you consider changing your clauses to say that it's the agent or the conveyancer. Let's take that off their shoulders. Let's keep our deals clean. Let's keep our deals uncomplicated. Okay. I want to go back to when it is invoked and the fact that I said that it needs to be invoked when the seller wants to accept that competing offer. I know that in the market, many times what happens is that the seller accepts that second deal. I don't know why. I mean, I do know why. There are several reasons for that, especially if deal number 1 was done by one agency and deal number 2 was done by another agency. Because then the control that you have to speak to your seller is taken away from you. And there's another agent that's now also speaking to your seller. Sometimes it's because ignorance of the law. Sometimes it's because of confusion. Sometimes it's because they are told to accept that other offer. And what happened in my office at the end of last year is that I got a deal from an estate agent where the seller had the right to continue marketing, not only through that agency, but on the open market. They were then presented with an offer by another agency. Didn't tell me, I didn't know it. Agent number 1 didn't know about this. And then I was sent an accepted sale agreement by the seller and confirmation that notice had been sent to buyer number 1. I immediately contacted buyer number 1 and I said to them, did you get the notice? Yes, we did. Okay, so when did the 72 hours start running? They told me when it started running. And they said to me, but it's okay, Anastasia. We're going to meet this. And I dealt with my buyer who has that 72-hour period to meet or beat. And they did. We amended the first sale agreement. We did all of that. And I said to the seller, Mr. Seller, you may have a problem. And that's what exactly happened. Because what happened was there were now 2 sale agreements, 2 concluded sale agreements. Because the agent, the second agent, told the seller, your buyer, your first buyer is never going to meet or beat this. Sign it, accept it. Let's send it to our conveyancer. And that was done. And then there were 2 agreements. And I stepped in as the conveyancer of the first deal. And I said, first in time, first in law, it's been they've met it, they've beaten it, we are going. Mr. Seller, you are compelled to go with the first deal. And the seller was very happy to go with the first deal. But the buyer on the second deal put the seller in breach. And the agent on the second deal claimed commission because the seller had accepted that offer and commission is deemed to be on their agreement to be earned on conclusion of the sale agreement. It was an absolute mess. And I just, I sorted it out. Of course I did. But I sat back and I just thought to myself, who was holding the seller's hand? How could this happen? How could the seller have been put in this position? He didn't know what he was doing. He was relying on that agent to hold his hand and to explain everything to him. I know, granted, sellers often tell us, don't tell me how to do things. This is how I want to do it. This is how I'm going to sign the agreement. It doesn't matter that they say that. We are obligated because of the positions that we hold to hold their hands and to take responsibility in explaining things to them. In the end, we resolved it. What would have changed that and what would have made it easier for the seller is if he had accepted the second offer subject to the cancellation of the first offer. But everybody forgot to put that clause in the sale agreement. So there are 2 points that I want to make here. The first point is, when does your seller invoke the 72-hour notice period? When the seller wants to accept another offer, before the seller accepts another offer. If the seller accepts another offer and then invokes the 72-hour period, which is not technically correct, and that is not what I'm telling you to do. But if that happens, that sentence, subject to the cancellation of the first offer, must always be put in the agreement. On Monday, I had a seller who phoned me. She concluded a deal with, and I'm going to say who it is, because I'm not pointing any fingers and there are no fingers to point. She concluded a deal with Fine and Country. That deal was subject to a bond, a deposit, a bond, and the sale of the purchaser's property. A conveyancer was appointed and they were running with that deal. The deposit had already been paid. The bond application was in, but they had 60 days to sell their property and they hadn't yet sold their property. The Fine and Country agreement reserved the right for the seller to continue marketing and to invoke the 72-hour clause. She called me because she was presented from another agency, First Realty, an offer, a competing offer. The Fine and Country deal said a competing offer. And the second offer was a deposit, it was a bond, it was the same purchase price, but it was not subject to the sale of the purchaser's property. And she said to me, "What must I do? I want to accept this. What must I do?" I said to her, "Well, if you want to accept this competing offer, the Fine and Country office sale agreement says notice must be given to the seller through, I can't even remember if it's through the agent, through the seller, but I said to her, I'll help you with that notice if you want me to help you. I've got the details of the buyer and the attorney and the agent. I'll invoke this notice on your behalf. And as soon as I send it out, the 72 hours start running." And she said to me, "Anastasia, but I'm not so sure. I'd rather want to wait until buyer number 2 puts down their deposit and gets their bond. Then it's non-suspensive. And then I want to invoke the 72-hour clause." And I said to her, "That's not what the law affords you. The law affords you to invoke this notice when you want to accept a competing offer. Unless Fine and Country's contract says you can invoke it when the second competing offer is non-suspensive. If it says that, then you can do that. If it doesn't say that, then you can't do that." And it didn't say that, so she couldn't do that. If she wanted to compete, then she'd have to invoke it immediately before accepting. But here's the tip. And here's the kicker. A seller doesn't have to invoke just because it's reserved in the contract. The seller can choose to do what this buyer or what the seller wanted to do. In other words, is to wait and see. And I said to her, "Okay, if you want to wait and see, then you're never going to invoke. What you're going to do is you're going to accept the second offer, subject to the cancellation of the first deal. And you're going to send it to me, and I'm going to open a file. But I'm never going to register this deal unless buyer number 1 doesn't sell his property, or buyer number 1 doesn't get his bond. But you can't invoke." I hope that makes sense. And if there are any questions in that regard, you're more than welcome to ask me. Okay. So I also just want to tell you, what does the law want? What does mother law want? In my mind's eye, the law is a female. Okay. It's not a male. What does she want? She wants the seller's interests to be protected. And she actually wants buyer number one to win. That's what the law, if you're going to, if she had a voice and you could ask her, that's what she would say. She would say, estate agent, do whatever you can to protect the interests of the seller. But I want buyer number one to win. And why is she saying that? She wants buyer number one to win because buyer number one is the person who did put pen to paper first. They are the person who did put pen to paper first. Of course, if they can't meet or if they can't beat, they lose. But the process in meeting and beating must be done properly. And they must not be prejudiced by that process because things then get done in the wrong manner. For example, we don't understand what 72 hours means, or we don't understand when we must invoke, or we don't understand that we shouldn't accept a second offer. And that is why I'm telling you what mother-law wants, so that we can all understand, yes, maybe, eventually, buyer number two wins. And it might not even be your deal because it was an open market to continue marketing. And you lose out, and buyer number one loses out. But as long as the process is done properly and everybody understands that process and there's absolute consensus about that process, mother-law is happy because everybody's interests have been properly protected by the property practitioner and the law. Okay. When it comes to, so we need to have clear consensus on what does it mean, how is it actioned, and what are the implications. And as I said before, it's not difficult. These aren't difficult concepts, but we make them difficult and we make them complicated. So it starts with us going back, looking at our clauses, and taking into account what Anastasia said this morning, and then just taking it from there and implementing it accordingly. And I know what some of the leapfrog branches agreements look like, and I know that they are good. For many of you, all it's just going to take is to bear in mind what I've just said today and then to implement it. When it comes to the subject, when it comes to the subject to the sale of the purchaser's property, once again, the wording of that clause is not dictated by anybody. It is created in your contract, and everybody must have absolute consensus on it. Some agreements will say subject to the sale of the property by a certain date. Some agreements will have 3 different options. Subject to the sale of the property by a certain date and all suspensive conditions being met by a certain date. Subject to the successful conclusion and registration of the property because it's already been sold. There are a whole lot of different scenarios that exist, and your contract must allow for all of them. Or if it doesn't, and you create it every time you deal with a buyer who needs to sell their property, then you need to bear in mind all the different options and what they really mean to ensure that there is absolute consensus between the parties. What does your seller want? Your seller wants registration as soon as possible, even though the buyer needs to sell their property. So what the consensus needs to be in your seller's mind is, what does it mean that the buyer needs to sell their home? What does it mean? How long is this registration process actually going to be? Many times when I do a deal and the buyer then sells their property and I tell the seller and we get the deal and we open that second file because we're linking the 2 deals. And the seller then says to me, does that mean that now I can expect transfer to happen within the next month or so because they've already paid the deposit, they've already got the bond, and now they've sold their property? No, it doesn't mean that. It doesn't mean that. It means your property is going to be registered depending on the timelines in the agreement that your buyer has just concluded with their buyer. So I'm going to have a look at that, Mr. Seller, and then I'm going to come back to you. And then I do come back to you and I say, another 3 months or another 5 months, because that deal is subject to the sale of the purchaser's property. Now, you can't build in all those scenarios into your agreements. But my tip for you today is to ensure that there is absolute consensus between the seller and the buyer. And although there isn't consensus with regards to the timelines, because nobody knows what the buyer's sale agreement is going to look like, consensus does mean an understanding, Mr. Seller, that your registration will be dependent on the registration of the buyer's registration, and therefore taking into account the timelines there. And that's the discussion that you have with the seller before they accept your offer. And if they then say, okay, but then I want it to be, the condition is deemed to be fulfilled, the right afforded to this buyer to sell their property, that condition is deemed to be fulfilled when all suspensive conditions have been met. And therefore, I want to reserve my right to continue marketing until then you need to link up those time periods. So it's not difficult, but it's that conversation. And I have such admiration for real estate companies such as Leapfrog, who have all the different scenarios in their clauses and have thought about it when they wrote the agreements and when they train you, and therefore they guide you and they give you all of those clauses. But don't accept, because those clauses are there and you therefore delete two and the one is applicable, that your seller understands that. It's actually your seller that must choose which clause is applicable, not you. It's your seller. After you have explained to your seller what the situation is. Yes, the buyer has sold. Or no, the buyer hasn't sold yet. They only want to put it on the market now. Or when did you say you're moving to Cape Town from Joburg? Okay, so I need to take into account the set timelines in my agreement and make them shorter or make them longer. You have to have those chats with the seller, even though you're guided by all the different options that Leapfrog give you in the very well drafted agreements. And then it's the seller that makes the choice. It's not the agent who makes the choice. It's the seller that makes the choice, with the agent holding the seller's hand. And that's the last tip. Are there any questions?
Thanks, Anastasia. I think you've given some really good advice. Even I've learned something. Any questions, anybody? You always have a great way of telling interesting stories.
Yeah. If only they were fantasies, Michelle, and they didn't really happen like this.
No, they said that was brilliant. Thank you so much, Anastasia, and thank you for your time. We really appreciate it.
Thank you, everybody.